Hey everybody, hope you are all doing well. Hope you had a nice Thanksgiving. I am trying to, let's see if this will work. Okay, I'm just trying to go live on Instagram. We'll see if it actually works here. But anyway, I hope everybody had a nice Thanksgiving and that you are all doing well. I don't know why I'm not able to get, I don't know, Instagram doesn't seem to be wanting to work today. Okay, well that's okay. We'll try one more time here. Let's see here. It says go live, and I'm hitting live, go live, but nothing's happening. Okay. Anyway, I'll try to keep playing with this as we go along. Any case, one of the things I wanted to do was to talk to you all about something that's popped up at a few recent hearings, and this is just, I mentioned this before, but it's happened today. Not a big deal, but I just want you to be aware of it. And that is, when you file for disability, you choose an onset date. That is the date you claim that you became disabled. That's called, again, your onset date. And it's really important to look to see whether or not you have earnings after your onset date. And those earnings, in some cases, could be, accrued vacation. It could be accrued sick time. It could be an employer just paying you because of loyalty, a severance package. It could be, I know back during the COVID, they had the PPP program. That was one today. But it's always important to look at your earnings record to see, do you have earnings after the onset date? Because if you do, the judge is inevitably going to want to know about it. I had a hearing a few weeks ago where my client was receiving a big severance package, and basically the judge was, wanted to see the severance package. So, it's just, and we had to get it to him, and he eventually approved the case. So it's just a matter of, what the judge is going to want to see, but you can almost be guaranteed that the judge is going to want to see that. So just be aware of that, and, pay attention to that and make sure that you have that information available. Okay, let's go to some of the comments here. Actually, before we do that, let me go ahead and I'm going to try one more time with the Instagram, and let's just see if it's going to work here. I'm not sure how many people watch me on Instagram, but I did post it there, so want to make sure that they are able to see it. And it doesn't seem to be working. Okay, well, no Instagram today. All right, let's go to the comments here. We have MD7SSA. I will be seeing a new pain specialist for the first time for back pain and lumbar radiculopathy. I've had 2 or 3 epidurals in the early 2025 and a medial branch block in mid-25. Nothing helped. If suggested, may I reject an epidural steroid injection? Yes, you can. I think that the rule in Social Security is that you have the right to refuse to undergo any kind of invasive procedure, something that could be dangerous. Epidurals are pretty common, but you're sticking a needle in your spinal canal, so there is an inherent danger. In fact, if you look at the if you look at what your doctors say, the papers they give you, it will say very clearly that there is some danger in having an epidural. So if you can basically let the doctor know that these other conservative treatments have not worked. That's number one. Number two is, I'm really concerned about somebody sticking a needle in my back, and I'm going to choose not to go that route. That will not hurt you. And I had somebody today ask me about, not wanting to take a medication because a friend of this person had taken a medication and the pharmacist or whatever gave them the wrong dosage, and the person had a really bad reaction. And so the question was, can I refuse to take a medication because of something bad that happened to my friend? My take on that was, I don't think that's enough of a reason. I mean, if you're concerned about the medication side effects, if you're concerned that the medication may interfere with other medications you're taking, if you're concerned about possibly a bad reaction because you're allergic to certain other medications, okay. But a friend got the wrong dosage or the wrong medication from the pharmacist, I don't think that's a legitimate reason to say I'm not taking it. You can come up with a better reason, but again, I think in an epidural situation, being concerned about somebody sticking a needle in your back, is probably a legitimate reason. And they go on to say, worried about another epidural, I've had bad osteoporosis, and Mayo Clinic and others say the injections can be bad. Right, because osteoporosis obviously is where there's brittle bones in the back, and the steroids injections can cause further damage to that. So I think that's a perfectly legitimate reason to refuse to take an epidural. I do think it's important that you explain that to the doctor. I'll make sure the doctor is aware of why you're doing it, even to the point I would tell you to write an email or a letter to the doctor saying, I've done some research and my concern here is that A, I'm concerned about a needle going in my back. B, because of the osteoporosis, I'm concerned that the medications in the steroids of the epidurals are contraindicated for that. So I don't think that's something I want to do. And that way it's in the record. And if you're questioned about it later on, then you can certainly explain why. Realize an epidural, just like these other issues, the medial branch block, these are all Band-Aids. They're not going to cure the problem. They're just going to mask the pain for a while, presumably to let you, maybe loosen up or to do some exercises, to physical therapy to make you feel a little bit better. But an epidural doesn't treat the problem. I mean, obviously surgery would treat it. That's a whole different story. And again, you can certainly refuse surgery if you don't want it. And even if you have a condition that theoretically could be significantly improved by surgery, and you elect not to undergo surgery, and you remain unable to work, that would not be a grounds for denying disability for you. So I think the same thing applies for an epidural. So yeah, I don't think that that's a problem. This MD says I'm on gabapentin. Gabapentin or Neurontin is a medication for nerve pain. It is known to have, they call it GABA brain, makes it really hard to focus and concentrate. I think that I would explain to the pain doctor all the negative side effects that you've had with the treatment so far, and see if there's anything that can be given to you that maybe is less likely to have those side effects, maybe reduce the dosage and maybe reduce the pain effect reduction element too. But, presumably you want to have some layer of pain reduction, but if the side effects of the medications or the procedures are things that you can't tolerate, then you may not be able to pursue that. Now, the problem obviously is if the pain doctor says, well, if you're not going to pursue anything I'm suggesting, then there's nothing I can do for you. And that may be the case. In that case, you go back to your family doctor, orthopedist, and consider surgery. And I've had cases where, a person was released by the pain doctor because there's nothing could be done. They didn't want surgery. And so they basically, they were in kind of I'll check in a couple of times a year, but there's really nothing the doctors could do. We had the issue of wanting to make sure they were going to the doctor, to have updated MRIs and things like that, but there's really nothing the doctor could do. So I would tell my client, check in once or twice a year just to see, is anything getting worse? Is it still, is the need for surgery becoming more of an emergency, or is it still recommended but not an absolute emergency? But yeah, it's kind of ridiculous to have to go to the doctor for the doctor to say, there's nothing new I can tell you. Either you go to pain management or surgery. You don't want either one of those. I can't really help you. But for Social Security, you have to have that medical record. So it is what it is. Okay. Vinny, one of my clients, who we do have a hearing date. And if you saw in the comments, Vinny and I drew a really good judge in that case. So I'm really happy about that. Although I will tell you, I had this happen to me today. I prepared a case. I think it was a good case. And the judge we had was a really, really high approval judge. And so I wrote the brief, addressed it to the judge. And then yesterday they switched judges on me, and they gave me another judge who's also a little bit higher than average approval, but not as high as the first one. Again, we won. We're going to win. But, it did make me pause a little bit because now I got a new judge. And the hearing was obviously different. I don't know what would have happened with the other judge. This case is going to get approved regardless. But, what obviously would concern me, if you have a 65, 70% approval judge, then they switch it out for a 30% approval judge, that would not be a good thing. That happened to me one time years and years ago, but hadn't happened since. But, right now, Vinny, we have a really good judge. So I'm very much, looking forward to getting this done. And as Vinny pointed out, we filed it as an application in September of 2024, March 5th hearing, so about 18 months. That's actually fast. I mean, a lot of times it's 2 years, but 18 months is not atypical. But thanks, Vinny, for letting everybody know kind of what your experience was. 18 months is not atypical, and it's ridiculous that you have to wait that long, but that's the system. And early happy birthday, Vinny, by the way, as well. I have a calendar. I put my clients' birthdays on my calendar, and I know Vinny's is coming up in a few days. Ed Dog 1, Ed, you're a new viewer. Welcome. Thanks for tuning in. Just turned in the 454. Just received the 3373. How long to hear a decision after they send this one back in? We're talking about these function reports and so forth. At the administrative level, generally speaking, and again, there's no definitive time frame, the fact that they've sent out forms means that there's an adjudicator assigned to your case working on the file, which is good. They send these out at the same time. Typically, they send out medical requests. Normally, they calendar the medical request to come back in about 6 weeks, 4 to 6 weeks. If they don't come in, the medical records don't come in, they send out another request, another 4 to 6 weeks, and then they send it off to the medical specialist for a decision. So you're probably looking at a minimum of 3 to 4 months, probably, given the backlogs and everything, 6 to 8 months. But let's hope it's more of a 3 to 4 month type of thing. And those forms, by the way, are actually quite important, because it give the adjudicator an idea of what you're going through in terms of your actual functioning. One really important part of it would be the work history part, when they ask about what you did, because you put in there how much you lifted, how much you were standing, and that is used by Social Security to determine whether you are working at a light or a medium or sedentary type of job. If you say you're standing and walking more than 2 hours a day, that puts you in the light category, even if your job is characterized as sedentary. In other words, every job is characterized by the DOT, the Dictionary of Occupational Titles, outdated resource, but they still use it, as sedentary, which means sitting for 6 out of 8 hours, standing and walking 2 hours, lifting 5 pounds, frequently 10 pounds on occasion. Light, which is standing and walking 6 out of 8 hours, lifting 10 pounds, frequently 20 pounds on occasion. In the medium, it's 50 pounds on occasion, I think 20 pounds regularly. But the point is that a lot of people, or if they're working a sedentary job, computer programmer or something like that, but they have to be on their feet for 2.5 hours, well, that takes them out of the sedentary occupation. Now that's performed as light. And that might be because one of the questions that Social Security is going to ask is, could you return to your past work? If you did it at light and you're limited to sedentary, then no, you couldn't, and that benefits your case. So again, these forms, it's important to fill them out accurately. Think about how much you were lifting, carrying, walking, and standing. Really, really important to be, and think about it, not just, even if one day a month you're doing inventory, you had to lift 25 or 30 pounds. You put occasionally, maximum that you would have to lift would be 25 or 30 pounds, because it benefits you to make that, to show that job with the physical requirements that it really has. Because, when you got the job, presumably they assume you could do that. Even if it's one day a month, you could do inventory and lift 50 pounds. So that's part of the job description. So you want to put that in there. And then the other parts of these forms where they ask about, sitting, standing, and walking, you really want to, and I look at these when I'm doing my hearing prep. So many times people say, I can't sit for very long at all. I can't walk too far. I have to rest frequently. I've got to go to the restroom all the time. That doesn't tell them anything. You want to be real specific. I can't stand and walk for more than 10 to 15 minutes, and I've got to sit down. I can't
lift more than 5 pounds, or my back hurts. I can't reach overhead because of rotator cuff problems. When I sit in an office and they're asking about sitting in an office type of chair, I have to have my legs extended, or I can't sit in a straight back chair for more than 10 or 15 minutes. I have to take unscheduled rest breaks for 15 to 30 minutes 3 times a day. That's how specific you want to be, because if you just talk in generalities, it means nothing. I mean, if I said to you, here's a person who's applying for a job, and they sometimes have to sit and rest during the course of a day for a few minutes. Well, what does that tell you? It doesn't mean anything, but if they have to sit and rest for 15 to 20 minutes 3 times a day, that's an unscheduled 15 to 20 minute break 3 times a day. So that's why it's so important to be very, very specific. It says I have to list a third-party contact. This is a CDR, okay? Homeless, only option is my sister. She exaggerates so much her answers may seem untruthful. Use her or leave blank. I would probably tell you to put your sister on there and obviously encourage her to be truthful. And I'm sorry you're homeless. I mean, this is such a tragedy about these when they do a CDR and they terminate your benefits. I think that it's probably better, unless you really think that she's going to be completely inaccurate. Worst comes to worst, if she exaggerates the limitations you have, they won't give it much weight. I think that's probably even better than having nothing at all. But, ask her to be specific as well and talk to her about it. Nothing that says you can't, I wouldn't say not sit there and write it out for her, but explain to her, this is what my life is like, and ask her, if she concurs and she observes you to, that's the way you want to put it on the form. You have to give them answers that answer these questions as best you can, as quickly as you can. But the key concept here is, Ed, you got to be very, very, very specific and avoid the generalities of not very much, not very long. I piddle around. I don't do much at all. I'm in the process of quitting smoking. None of that. You got to be specific. You just can't do that, because it's just going to really, really hurt you if you do. Okay, Rodney is one of our regulars. Hello, Rodney. Good to see you. And I'm looking forward to another informative one too. But thanks for tuning in. Felice Falcon. I have an FCE that says I can do 8 hours of sedentary work. How does one argue against that? Well, realize the FCEs, and what Felicia is talking about, is a functional capacity evaluation. And so a couple of questions. One is this simply a form filled out by a doctor? Is it a doctor you see regularly? Was it a full-scale FCE exam with a physical therapist? It kind of depends. If it's by the doctor, that didn't actually test you, that's one thing. If it's by a physical therapist who did, that's going to be more difficult. The way I would address that would be, and you can't leave it out, but you have to submit it. It doesn't really talk about pain, and you could certainly, the argument I would make would be, yes, if a gun was put to my head, I could do 8 hours of sedentary work once or twice, and then the pain level, the accruing pain level, would get to the point where by day 3 I would be just in excruciating pain. So the FCEs generally talk about physical capacity, not about the impact of pain. So that would be one way to address it. The second thing would be, there may be, assuming this is a physical FCE, are there mental health issues? So you could certainly say that there's a level of depression and anxiety I'm dealing with that obviously the FCE does not address, and that increased levels of pain trigger more anxiety and depression in me. And so that, yes, even though I have the capacity theoretically to do a sedentary job, after a few days, the high level of pain would trigger this terrible anxiety, and that sort of becomes a cascading type of thing where I would have a really hard time being reliable. And then, of course, the other way to do it would be, if there's other medical evidence to suggest you have less capacity, you could point to that, saying that there's a conflict in the record.
my testimony is evidence, and my feeling is that I would have a really hard time getting through 8 hours at a sedentary type of job. Another point, again, I'm just thinking off the top of my head, sedentary, does that contemplate a sit-stand option where you need to stand up and walk around? And, you could possibly argue that the FCE assumed that you would be standing up and stretching out at the work site, but in reality, you have to walk around. That would take you away from the work site and be more off task. That would be another way to address it, that the FCE, obviously did not observe me over, a week or 2 weeks or a month. It was kind of a one-day thing. And yes, one day, if I had to do it, I could do it. But I would have to stand and walk around. That would take me away from the work site. My focus and concentration would be impaired by pain. I would have a hard time maintaining employment. So, the physical capacity is one element of what it takes to perform a job. And I would look at the mental elements, the focus, the concentration. If you're on medications, the effect of the side effects of the medications, are there mental health issues going on or other medical issues that would add to the burden that would make you less reliable? So I think you just have to point to all those things. But yes, at the end of the day, having an FCE that says you can do sedentary work is not as desirable. Obviously, though, if you're over 50, you still have the grid rules that could apply, because being able to do sedentary does not take you out of disability if you're over 50. But assuming you're under 50, you're going to have to, come up with different arguments to defeat that. And personally, what I would do is, I would identify, and I've just gave you a bunch of them here, but I would identify those arguments, in writing to a judge as part of a pre-hearing brief. And, just to rebut evidence that, again, this is a one-time visit. It doesn't contemplate, extended time in a sedentary type of job. It does not and also, how does the FCE, facility define sedentary? In Social Security, a sedentary job allows for 2 hours standing and walking. If this says you can do 8 hours sitting, but doesn't say you could do 2 hours of walking, you're not sedentary for Social Security purposes. So you got to make sure that the definitions are the same. So those are some things that I would do. I would just try to do it in writing and just kind of, go after the conclusion that the terms are different, the definitions are different, doesn't contemplate mental health issues, medication side effects, sit, stand things, and just attack it that way. And that's how I would do it. Okay, I hope that was useful. Stephen, how are you doing, Stephen? Is it difficult to be approved for disability if you have PTSD from military service? I was actually working on, somebody had actually sent me an email about that, and I was actually going to put together a blog post about it because I think it's an interesting question. My experience has been that with any mental health case, the older you are, the better. So if you're over 50, even though it's not an exertional problem, it's just better because Social Security judges kind of inherently know that people over 50 are going to have a hard time, finding a new type of job, transitioning to something new. So that's kind of a big picture thing. Whether you're under 50 or over 50, the PTSD, what I typically would ask my client is, tell me about the trauma. What did you see? What happened? In the military, a lot of times it's dead bodies or, having an IED explode 10 feet from where I was, or I was sitting in a truck with a buddy and we're talking. The next thing I look over and all I see is a mass of blood and brain tissue, and they shot him and not me. You have this survivor's guilt, or being in just an incredibly stressful, is your life going to come to an end the next minute type of environment for 6, 8, 10, 12 months. So I think that, the trauma, the nature of the trauma is important. I've had people talk about different types of trauma, that they didn't see it themselves, but they heard about dead bodies, or their friend came in and told them that they were, seeing, IEDs. It sort of has to happen to you. So I think that, what judges are looking for is a trauma that has happened to you personally, that, presumably wasn't a one-time thing, although obviously a one-time trauma could be could generate PTSD. But if it's sort of I've had the best success with people who've had sort of an ongoing, they were in a battle theater for 8, 10, 12 months. They were constantly out in the field. They saw people being blown up. They had to shoot a civilian because they thought the person had a bomb. I mean, just there are things that you can relate back that would really, demonstrate that the trauma is very, very real, that you relive it. And then your testimony about nightmares, not being able to sleep at night, the hypervigilance that a lot of people have. They go to a restaurant, they need to be in the corner where they can see everybody coming in, reaction to loud noises or flashes of light, things like that. You can have a third party, a spouse or a relative or a friend talk about, I was with Stephen, and a siren went, was going behind us, a fire engine behind us, and Stephen got very, very anxious and had to pull over and ask me to take over driving, something like that. Or we were at a movie and there was some gunfire, and Stephen literally hit the deck and went under the seat. Just things like that, where you can just demonstrate with third-party statements the reaction you have. I've even had people talk about, this is more with, females who've been sexually abused in the military, which is a huge problem, by the way, but it's a different story for a different day. But, they would say that a male supervisor would be something they would have a really hard time with. Or they would say that a male with a beard or a mustache, would be a real problem because the person that was their abuser had that. Or they wouldn't want to be in an environment where they might have to be alone with a strange male, So in other words, let's say they're in a retail store and there's only 2 people in the store, and people would come in and they might be alone in the back of the store with a male. That would create a real problem. So I think you want to identify the triggers of the PTSD as much as you can, and then describe what happens, and then talk about the treatment, how it has not really helped, that the medications haven't really helped, or they make you feel like a zombie, or that you're getting treatment at the VA and it really hasn't been much help at all, and that you're still in this situation where any sort of trigger can put you in a state where you have to leave. You wouldn't be reliable, and this is a sort of type of trigger that could happen. Just getting to work. I mean, driving in the car. I was talking to a client, just the other day, and he was saying, when I'm going to work, part of the problem I had was, I couldn't go to work, I couldn't drive during rush hour because having cars around me, made me feel really, really uncomfortable. So I made an arrangement where I could go in at 10:30, 10:15. There wasn't as much traffic. And even then it was, if there was a traffic jam, it got me really, really freaked out. So yeah, I think you just want to go into detail about that. So yes, you can be approved. And I guess the final point I would make is that the level of impairment needs to be more than mild to moderate. It's got to be extreme, where it really takes you out of doing anything that you're trying to do, that forces you to go home, or that your recovery from an episode is 3 or 4 hours, or that when you have a trigger, it could really make you just non-functional for again, 3, 4, 5 hours, something like that. And that you've gone through intensive treatment, you've gone through deconditioning, nothing's really helped there. You've gone to VA group therapy, that hasn't really helped. You've tried all the different medications, that hasn't helped. I think that's the kind of picture you want to paint with PTSD. But going back to the beginning, the trauma needs to be, really, in my opinion, needs to be something that happened to you. Secondhand trauma, judges tend to be a little less receptive to that. Zippy61. Hello, Zippy61. Hope you're doing well. Christina, one of my regulars, says, hello, Christina, from California, and I hope you are doing well. And Christina says, please share the live stream, I think is what she means, with your friends and family. I guess she was on before we went live. So yes, please do that. Thanks for my advice, Daisy. You are very welcome. I enjoy doing this. I like to share what I know. Okay. Bacon Craft says, if I change bank accounts now, will my next check go to the new account? I don't know. That's really a question beyond what I know. I would generally tell you that Social Security is backlogged. So I would not close the old account. I would leave it open until you're sure that the new bank account is working. Probably the checks are going in without a problem. And I think that would be a wise thing to do. So don't close the old account until the new one you are sure is receiving the money. Powder Puff says, what is the customary time frame for reviewing your case once again after you're approved? That's going to really depend on the code that Social Security assigned to your case. Sometimes judges do it, sometimes Social Security does it. They will evaluate cases and code them as either 1 to 3 year review, which means they think that you're likely to going to get better. For example, you have a surgery scheduled for 2 months from now that would presumably relieve the pain in your back, that you could go back to work. So that might be a 1 to 3 year review. There's, I think, a 3 to 5 year review, which is improvement expected, but probably more than a year, and that might put you on a 3 year review calendar. Then you have the 5 to 7 year review where improvement's not expected, and they probably won't review you. They might send you the short form where you basically indicate whether you've done any kind of work, but they probably are not going to assume you're going to get any better. The problem is this information is not readily available. I think you could possibly call Social Security and ask what kind of review calendar you're on, but I would say, if your condition, if you're older, if you're over 50 and you've got a condition that's not likely to get better, you're probably not going to get reviewed other than the random short form review that comes out to everybody, and just never know who's going to get that. Mary Charlene, how are you doing, Mary Charlene? I've been through injections on my back, and I feel like that's why I'm suffering now. So I think what you're saying is that maybe the injections did more harm than good. I think in the Social Security world, you got to be careful about going in and saying, I think that's why I'm suffering because of the epidurals, or I had a client telling me the other day that, he's taking Neurontin or gabapentin and his teeth were rotting out. Maybe that's and there is some, if you look at the WebMD description of Neurontin, that is a potential side effect. It's somewhat rare. I don't know that you want to be saying to Social Security, to a judge, that, I feel like that the injections did more harm than good. That's kind of a medical conclusion. I'm not saying it's not true, but it would be more persuasive coming from a doctor, because generally speaking, epidurals, if they're done correctly, will give you some limited relief, or they might not give you any relief at all, but it's rare they're going to make things worse. So I think that's kind of a non-standard type of reaction to them. And, if you go in and you say, I think the epidurals made it worse, it almost sounds like you're looking for a reason not to agree to additional treatment. And you don't want to be seen as resisting treatment that can improve you. Really, from Social Security's perspective, they want you back to work. They want you to go back to work. And so if you are, basically saying, well, I know that these injections caused me all this harm, and it's just, your thought, it kind of looks like you're not really motivated to improve. I'm not saying that you're not. I'm just saying that's kind of what the look would be. So again, I would say that, I would keep your suspicions to yourself, talk to your doctor about it. Maybe there's something in the literature to suggest that, in 15% of cases, epidurals make things worse. But, I don't know that I would just offer that opinion. That's, not a medically qualified opinion about that. All right, my Autumn Harvest Dude Ranch. We are doing well. How are you doing? I'm doing good. I hope the doodles are doing good as well. Sometimes I have Sadie down here, but she's been kind of needy lately. She keeps demanding to be played with, so left her upstairs today. Elliot Franco, happy holidays. Thank you. Yes, we had, hope everybody had a nice Thanksgiving. I did, went to a friend of mine's house. He had recently moved into a new house, very nice house. There's still some things need to be done, but there was, a bunch of people, some I knew, some I didn't know, but it was very nice to just kind of hang out and talk. I think a lot of us are just, very focused on our, our cell phones and our tablets, and something nice about just going to somebody's house and just sitting around and talking. My friend was nice enough to invite my whole family, so we had the grandbaby, my daughter, son-in-law, son, my wife, and so it was just very nice, relaxing Thursday, from about 4 on, and we just sort of hung out and talked and just chatted about nothing in particular and ate, some good food. Everybody brought something. It was really a very nice, nice Thanksgiving. So I hope everybody else had a good one as well. Mary Charlene. All I've been told for years is chronic pain, radiculopathy, degenerative disc disease, sleep apnea is a lot. So it's been since 2017 to the Niles Administrative Law Judge hearing to nail a reconsideration. Now have a law firm. I'm not sure. It sounds, Mary, like you've got a lot of things going on. And, again, you're the one who asked about the injections possibly making things worse. And certainly with autoimmune conditions, it is possible that certain treatments for one thing could trigger other things to get worse. But again, that's a medical determination. And, you've got kind of a chronic pain syndrome here, which I don't doubt. I mean, I know people have that. You have to walk a fine line because, when people have all these diagnoses, fibromyalgia and sleep apnea and chronic pain, radiculopathy, judges are very sensitive to people who've sort of invested in the idea of being disabled, that they just basically, they keep coming with more and more things that are wrong with them. And so you have to present yourself as a fighter, that you don't want to be not working, that these, you're fighting your own body, but that you've not given up. Because I've seen more than a few judges, you can just tell their attitude is this person has decided they're disabled, and I'm going to discount a lot of what they say because I think there is an ulterior motive here. They want to get on disability, and they've decided that everything in the world's wrong with them. So you got to be careful about that. So again, to combat that, I would, make sure the judge is aware that you are fighting this every step of the way. You do not want to be disabled. Okay, so we get that. You got a law firm, and I'm sure your lawyer will help you on that. Okay, so P. Brown says, I spoke to DDS, which is Disability Determination Services. This is the office that makes the administrative decisions to make sure they've received your medical records. They have. They wanted to do a mental health consultative. So they'll send you out. Normally, there's a panel of doctors, of mental health professionals, psychologists, typically, who are on the panel, and they just get assigned based on their availability. So sometimes you find situations where there's not a lot of doctors available, and especially this time of year, so it may take a while. So I would give it a few weeks. And if you don't hear anything certainly by the end of the year, starting in January, call back and say, look, I've been waiting for a month. Nothing has happened in terms of getting me to a doctor. Cynthia, okay, I finally got an adjudicator. Are they going to have me go to another doctor? Possibly. I see cases where there may be 2 or 3 consultatives. They did one year, then they do another one the next year, the third year. That could certainly happen. It's just going to depend on whether the evidence they've got is enough for what their needs are. And Cynthia says, good evening to all of us. And we say good evening back, Cynthia. Chip says, how beneficial is to get your file initial denial? Will this show more than a denial letter? Yeah, it's going to show the medical evidence they have. As an attorney, we will get electronic access to our clients' files pretty much within a few weeks of the representation beginning. So this is all during initial and recon. And so I can see what they've got. And sometimes I'll share that with my client and say, look, we need to get the neurologist, we need to get the orthopedic surgeon's records. Can you help with that? The adjudicators are supposed to do that, but they don't always do it. So I'm a big believer that the more information you have, the better. So if you can get that, that would be great. If you have an attorney, the attorney should be able to get it through ERE, Electronic Records Express, download it and send it to you. In fact, I have a client, I think she comes on here periodically, where we were trying to get her approved at Recon. And so, we had to change the onset date. It was one of the issues we had to deal with because there was work after onset. Remember, I told you at the beginning that could be an issue. So if there's work after onset, we got to explain it. And, we decided to change the onset date to after there was no work, but we wanted to get it to Social Security before the before the decision was made. So we did. Let's see here. I'm looking at something here, and I'm not seeing what this is. Okay. All right. Okay. Michelle says, I am 58 with fibro, spinal stenosis, irritable bowel, migraines, was turned down 3 years ago from a judge, maybe age. Well, you're 58, so at 55, you were kind of at the cusp, but certainly being over 55 will help you. Now, other than the spinal stenosis, the fibro is non-exertional, meaning it's a pain syndrome. The irritable bowel is not really exertional. Migraines are not exertional, and to meet the grid rules, you have to have a physical or exertional impairment. But the spinal stenosis certainly is. But as long as you're still insured, as long as you've got problems, if they've gotten worse, the earliest onset you could use would be the day after your unfavorable decision. But if it's gotten worse since then, and now you're older, you're 58, you definitely have a grid rule you can look at. The 202 grid rules, the light grid rules, then by all means go for it. So I think it certainly couldn't hurt. Chantet, judge approval rate is 47. That's about average. I would say that's kind of right at the average level. 47, 48, 49, that's average. That's not low, not high. It's right in the middle, right in the middle. Hey, Madeline. Madeline is one of my call screeners, works with me, legal assistant, does a really, really good job. And those of you who've spoken to her know she is really sharp and knows what she's doing. I'm glad you dropped in, Madeline. I hope all is well in Oklahoma. Probably kind of cold there, but I'm glad you're here. James Little, Sunshine State. So James is probably a lot warmer than we are. I'm in Atlanta. It's like 50 was a high today. It's probably right now about 40. It rained yesterday. It was miserable. Today was just sunny and cold. Tomorrow's going to be cloudy and cold. Supposed to play tennis. We'll see if that happens or not. I'm not a big fan of cold weather, but what are you going to do? Okay. How plentiful are CDRs for someone age 63 or above, found disabled from the grids? Almost never. There's no point in doing it because you're not going to not meet the grids. I think you're likely to prevail. So I don't think they're going to do one. Zippy 61 says, if I turned down another neck surgery, I'm almost 61, that hurt me. No, because I think that as long as you have a good reason that you're concerned about a negative outcome, you're concerned about going under anesthetic, these are all good reasons. Not having good results before, I would just put it in writing, make sure the doctor has it in his or her record so that if it's ever questioned, that Zippy basically said that she was not going to have surgery because she was really concerned about the side effects, and no doctor is going to tell you they can guarantee anything. And I've had people tell me the doctor said, well, 1/3 chance you get better, 1/3 chance you stay the same, 1/3 you get worse. Well, those aren't great odds because 2 out of 3 either not getting better or getting worse. So, many people would not go for surgery in that situation. Hey, Christy, you like the background? Yeah, I've got this program I use called StreamYard has built in some backgrounds, and I was using just kind of a blur so you wouldn't see my messy office. And actually, I have a green screen, which I probably need to haul out behind me, which would make this look better. But yeah, it's just, wanted to change it up a little bit. We've been cutting these up and putting them into like 2-3 minute little chunks and putting them on Instagram and TikTok. So I just thought, let me try something a little different. So why not? Okay, so Felicia's uh, FCE exam was done by a physical therapist. So yeah, those are, and her question was, it said she could do sedentary work. And I kind of gave you how I would attack that. But yeah, that's going to be evidence that's going to work against you. But I think you could still get past it, but it's going to work against you. Could the treating provider, Jack is responding to Felicia, could the treating provider write a rebuttal to the FCE? Sure, absolutely. I mean, it's not, that's what a lot of law is you have two competing bits of evidence, and a judge or jury, in the case of a civil matter, would have to decide which evidence is most compelling. And a doctor who's treated you for 3, 4, 5 years, has an opinion that's got value. FCE, on the other hand, though, they did, I'm sure, a lot of objective tests where they had you pull down on something, or had you lift, or had you bend. So it is, it's actually a test of your capacity. So yeah, it's going to make it more of an uphill battle, but not impossible. Okay, the functional capacity of the company. I love Centera Internal Medicine. They play games. I think if you've got a lawyer, trust your lawyer. Have the lawyer give you advice about what you want to do with, the functional capacity form and how you want to address that. This is a lot of you have an attorney. She said, looks good now. Okay, being 50 definitely helps. Disability Law Group, I don't know them, but again, if they've done this for a while, then they will certainly have an opinion, I'm sure. When your client receives the 3373, let me just give you the official name for that, SSA 3373. The function, I thought so, function report. I just think about function report or work report or whatever. I don't really think about the numbers so much. What I do is I did a series of videos where I went over the form line by line. And so what I typically do is I will send the client the video, and then I'll say, if you want me to look at your form before you send it, we send it in, or we'll send it in for you. If you want me to look at the form, I'll be happy to do it and give you my thoughts on it. I'm not a big believer in being involved in filling out forms because they're evidence. And I don't want to be in a situation where at a hearing, the judge says, well, the form you said you had to stand for 4 hours a day. Now you're testifying it's 6 or it's 2 or whatever. Why is that? Well, my lawyer filled out the form for me. I'm just not a big fan of that. I think it needs to come from the client, the claimant. I'm happy to review it, make suggestions. In fact, what I tell people to do is go to, in this case, 3373, just type in SSA 3373, doing it right, just like I did, and, fill out the form online or download it and fill out the form and send it to your lawyer. I have my client send it to me, and I'll make suggestions, or I'll ask questions. Is this what you really mean? Case in point, I was talking to a client a couple of days ago, and the question was about how much could he lift. And so he said, I think I could maybe 35, 40 pounds. I'm like, 35, 40 pounds, you realize that's like, 3 10-pound bags of potatoes. You think you could lift that? Well, probably not. People, tend to overestimate their capacity. So, sometimes I have to talk to them and say, look, a gallon of milk is 8 pounds. Look, my hearing today, I asked my client, how much can you lift? Probably about 15 pounds. So I said, well, gallon of milk is 8 pounds. You think you could do that 7 or 8 times in a day? Oh, no, I couldn't do that. Where 15 pounds came from, I don't know. So I don't typically go over it with them as they fill it out. I will, get the completed, I'll give them a video, get the completed form, and I'll call them up if I think there's something that we need to talk about. But I think it needs to come from the person, in my opinion. Felicia says, thank you. You're welcome, Felicia. Mary Charles. Okay. This is a person who's got a multitude of autoimmune conditions and some physical impairments. They want to send you to one of their doctors, and not surprisingly, my experience has been that Social Security doctors for physical exams are either going to not help you or be neutral. A lot of times they don't make any conclusions about functional capacities. All they really talk about is this is what the person is complaining of. So, when it comes to autoimmune conditions, I'm going to guess that the consultant is not going to help you very much, but you still got to go through with it. Lake City Bricks. I was found disabled in 22. My first case was denied. I've got a third hearing in front of a second ALJ. There'll be 2 medical experts testifying. Is this normal? Not normal at all. I think that the fact there are 2 medical experts is really unusual. I'd say about 10% of my cases, there's a medical expert. I don't think I've ever had one with 2, maybe once or twice. So that's pretty unusual. That says to me that the judge is probably going to listen to what the medical experts have to say and, go with their opinion, because he wouldn't have 2 there otherwise. Okay. Baron Kraft says they're good. I hope he's talking about me. But if not, you talk about disability group. Yeah, okay, that's fine. That's good. I'm glad to know that, you always want people to get in the hands of somebody who knows what they're doing. Okay, human medical expert had one of these with the process. Yeah, medical experts are kind of rare, but you can still attack them. A lot of times they're retired doctors who are only looking at the record, and you ask them, well, isn't it true that a person's pain is not going to show up in the record, and that it may be at a really high level despite what you're considered mild to moderate impairments? They're always going to say yes. So my experience with medical experts is a lot of them are kind of wannabe lawyers, and they will start pontificating on the person's capacity when they're really not in a condition, in a position to do that, based on just looking at the medical records. Had disc plate. I think Zippy was telling us, let me go back if I can find it. That's the trouble when people write a question, they have to come back to it. There may be 15 more questions in the meantime, and it's very hard to keep the train of thought here. Okay, Zippy's original about the neck surgery, and she's had, says another, so she's obviously had one before that did not go so well. Disc implates, non-disc implate, research. Yeah, I think those would be reasons to refuse it. It's not a long-lasting solution. It's somewhat risky surgery. It's very involved, multiple discs, and I've decided I'm just going to go with rest and physical therapy. I think that's not unreasonable for a dangerous surgery. 50 years old will be as hard. Yeah, call me. Yeah, so hopefully at 50 you now have the grid rules in your corner, so hopefully it works out for you. Alicia, how are you doing? Alicia, one of my clients here. Lake City Bricks, mine will have 2. They both lie through the teeth. Interrogatory is a really good attorney, but just wanted his thoughts. I would eliminate they lied through their teeth. It's not that they lied. I mean, what they're looking at is medical records, and they're saying, based on these medical records, we think that the symptoms ought to be here. The claimant, the patient's saying they're here. It doesn't mean they're lying. It just means that, they're saying your reaction, the side effects, the symptoms you're experiencing are a little out of proportion to the nature of the surgery or the impairment. But on the other hand, there are people, who just have really bad reactions to surgeries or have chronic pain conditions. So, you just have to hold your ground, stand your ground. Dolphin, hello from California. Hello, Dolphin. Christina, please don't forget to press the like button. Yes, Christina is my loyal listener who always reminds us of that. Thank you. Have a great night. Thank you very much. If I keep you on like this, I need to go to sleep, right? Okay, so Mary Charlene has got a lot going on, and I think your lawyer needs to be very specific about identifying the problems, choosing the ones which are most work preclusive, and really running with that. Alicia, let's see. Yeah, this is a crazy situation. When you get approved, you become eligible for Medicare 2 years after your first payment. So if you're approved in December of 2025, it's only count full months. Your 5-month waiting period, let's say your onset date was, in July or June of 20, let's say it's July of 25, the 5-month waiting period runs, so partial months don't count. So January, February, March, April, May. So June of 26 is month 6 or month 7 in this case, and it would be 2 years from March or I guess May of 2025. You're looking at May of 2027 that you have no insurance because it hadn't kicked in. Yet you may get a CDR asking why you haven't gone to the doctor. I have no explanation for that. But yeah, it's a pain. But I'm glad we did get Alicia approved, but that's really difficult. Income, yeah. The income being the SSDI. Crazy. Okay, here. Okay. Wouldn't make a change. Only not a catastrophic medical issue. Yeah. You don't want any catastrophic medical issues there. That would not be good with no insurance. Absolutely not. Pattis 47. Oh, okay. Yes. I did see that come through. I think we have not spoken yet because I was doing my hearing prep, but we will. But yes, absolutely. We will give it a good shot. I mean, I'm pretty good about spotting the good ones. So we'll talk and discuss kind of working theory. But yeah, I'm glad you reached out. It doesn't. Cynthia says, where in the SS page does it say if you're 1, 3, 5, 7-year review? It doesn't. It's a code. And we don't have access to it. I have somebody who told me they figured out how to get it. I hadn't been able to find him to find out why, and I'll see what I can find out. My wife and I love your channel. Well, good. I'm glad you tuned in. Have a good time with this. I've actually got a few guests lined up. Hard to get people toward the end of the year, but I've got some people lined up. I'm going to get Steph back, Stephanie Joy back. I've got a couple other people I've talked to over, a former Social Security employee. I'm trying to get a retired judge on. That's been more difficult than I thought it was going to be. But yeah, we're going to keep rolling. Do I happen to know the denial rates under Biden versus Trump? I don't. I don't know if those statistics have been released. But realize judges are independent, so I've not seen any statistics to that effect. I have legal medical records I got from a hospital. Medical records are documented from neuroscience. Mary Charlene, I mean, I know it sounds like you've got a lot of evidence and you've got an attorney. I would just tell you to work with your attorney, put the best face forward. But again, don't present yourself as a person who's decided you're disabled. Present yourself as a person who's fighting it every step of the way. All those records, let them speak for themselves. You don't need to say to the judge, I'm disabled. You need to say, I hate the idea of pursuing this. Cynthia says, information very appreciated. Well, I appreciate that, Cynthia. We do our best. I'll tell you, it can get, I find this practice area very rewarding because, when you take a case and it's going to win, and even though it may be a year and a half, like Vinny's situation, it's still very rewarding that just to know that, you took the case, you saw it, and you saw that the the chess game, how it was going to play out, and it actually worked out the way you wanted to, and that now your client has $2,000-3,000 a month coming in. That is very rewarding. You know, and but it also can be frustrating because, you know, for these cases to take 18, 24 months, you know, I can't imagine going for a year and a half, 2 years, excuse me, with basically no money coming in, and also the pressure of having to go to the doctor. You know, living with family and friends. I, you know, had a client, you know, my client today had to, you know, his wife left him, had to move in with his sister. You know, this is, you know, when you're 60 something years old, that's not where you want to be. You know, guy had a good job his whole life, and just things stopped working out, and you know, his whole life kind of fell apart. So yeah, it's heartbreaking. And you hear about people, you know, living in their car. The gentleman said he was homeless. I had the last week, 2 weeks, I had 2 of my clients pass away. I mean, just waiting, you know, and they had both had chronic medical problems, but, you know, 2 people died because the delays are so long. So that can be very frustrating. But again, it is very rewarding when it does work out, but it's still frustrating when it takes so long. I am Mr. Temple. I used some of the suggestions for disability adjudication, and you won. Great. That is exactly why I do this. I love that. In fact, if you would, I'm going to put the place to give me a review. If you find this useful, go here, leave me a review. If you find what information I gave you to be useful, then please post a review that says that. That helps, you know, other people know about it. And I'm thrilled. I mean, you know, there's obviously, you know, a lot of more people that watch my videos and the live stream than I represent. And that's fine. You know, I do this because I want to share what I know, and I love to hear. I've had people send me very nice cards and letters when they get approved based on what they've learned from the websites and the videos. That's great. I mean, I think that's great. I mean, if you can do it without an attorney, go for it. I mean, it doesn't offend me. I think it's pretty confusing, but, you know, some people can do it, and that's great. I'm glad you won. Maureen, good evening. Hello, Maureen. Good to see you back. You've been here several weeks in a row, I think. Charity has been diagnosed with autism, along with other diagnoses. Denied recently. The assessor was on vacation. They didn't know the end. Okay, and then what if the doctor is writing wrong information on medical records? Yeah, that's a hard thing to deal with, Charity, because, you know, if a doctor is writing something incorrect, you know, the first question is why? What are they writing? You know, their conclusions may be different than yours. You could find another doctor. You know, but when people start using the word the doctor lied or the adjudicator lied, they're not lying. I mean, I'm not saying that nobody ever lies. I mean, they could, but most of the time, just the doctor may have a built-in bias. You know, I remember there was a doctor here in Atlanta, law practice, and when you went to their website, I wish I still could find it, and it basically says, "Excuse me, kind of." Here we go. Talking for 2 hours straight can get your throat a little sore, a little raw. But the first thing on the website was, we are an ability medical practice, not a disability practice. If you're coming here because you're trying to get on disability, go someplace else. Because they felt like, I don't agree, but they felt like if you were thinking about going to disability, your mindset was you were already invested in it, you didn't want to get better. They only wanted people who wanted to get better. They wouldn't cooperate at all with me for disability. I think that's ridiculous, but you find that sometimes. So, you know, maybe Charity, you've got a doctor who just is very much about not pursuing disability. How often, or Eastern Zone, how important is it for the spouse to write a letter of support, testimony for an upcoming hearing? Does the judge weigh the details from a spouse? I don't think judges give the spouses, you know, letters or statements on the form SSA 795. I don't think they give them a whole lot of weight at all. I just think that you got a built-in bias. I just don't think it means much of anything. Can't hurt. And every once in a while, there may be some nugget in there that could be of value. But for the most part, I think, letters from spouses or parents or children, that's not objective. I mean, it's not, it's not third party. Much better to have it from a third party who doesn't have a vested financial interest in you getting approved. Got a great question for you. Okay. My wife and I receive every 3 years a disability update form. We've never received a CDR. Will eventually lead to a CDR? No, not necessarily. I mean, if you get in the short form where basically just ask, have you gone to work as the doctor said you're going to get better? There's just like 8 or 9 questions on it. Those are machine read. If you answer no to everything, they're machine read, and they generally are not going to do anything with them. It's just maybe you just have to keep filling out the forms. Yeah, I wouldn't lose too much sleep over that. Hope Georgia warms up some. James, yeah, I think James is in Florida. Yeah, I mean, we got this polar vortex that came in. It was like 32 last night, which is pretty cold, obviously, for us here. It's supposed to warm up to the 50s over the next week, maybe high 50s by the end of next week. Normally this time of year, we're in the 60s. So this is definitely a cold snap. Yeah, I hope it does warm up a little bit. I mean, I don't mind if it's cold as long as it's not rainy. I just don't like the cold and the wet together. But that's just me. I'm glad you addressed it. 4 o'clock lover. First time I heard of this, I felt influencing the judge. Yeah, I mean, look, Stephanie Joy, who I respect a lot, is a very good attorney. She's more involved in filling out the forms. She feels like the forms need to be filled out correctly, and she will sit with her clients and fill them out. Nothing wrong with that. I have no problem with that at all. And again, I think she's able to make, she's not putting information in there. She's not making stuff up. She's there with her client. I personally prefer to have my client do it on their own and then send it to me for my suggestions. That's just the way I do it. Everybody's done this a little bit differently. And like I said, I can obviously tell, I'm in the video. I did a series in fact, I even wrote a book. It's right now, I'm sort of in the middle of revising it, although it's been a long time because it's just time. But I wrote a book about the forms and how to fill them out, because so many people fill out the forms incorrectly that they're starting out with 2 strikes because they don't talk about the things that matter to Social Security, and that is vocational capacity issues. So again, the video, which actually was part of the revision of the book, and I just put a couple of them, I think for the 3373, I put two of them out there. And just like, here's how you fill it out. Here's what you need to know and what they're asking. This is what they're really asking. A lot of this is you don't know what they're really asking. And so this is, kind of what you want to do. What you want to do is just to know what they're asking and give them what they're asking. Cool iPad 5, okay. How do they look at personality disorder? Only thing they're looking at is how does it affect you in terms of your functioning at a job. You don't win or lose by a diagnosis. You win or lose based on how your medical problems impact you in a work environment. So that's how they look at it. All right, so Charity's saying, had some issues with your doctor's office, your OB, no depression, no agitation. You saw your other doctor by telehealth, no anxiety, which is the opposite of what is the reality of it. Whereas an OB is not a mental health provider, nor is a family doctor. So they're just observing that there was no overt symptoms of anxiety. It's not your psychiatrist or your psychologist. And, I would argue that a OB is not really trained to evaluate or assess depression, other than to say that you were not tearful and that you did not have any obvious signs of severe anxiety based on whatever they did at the office. So I wouldn't lose a lot of sleep over that. And again, that when I see that, I mean, yeah, could a judge say, well, Charity's OB said that she didn't seem anxious? Well, is that going to be more important than the psychiatrist saying she's on 3 or 4 medications and has severe anxiety? I think that the psychiatrist is going to give a lot more weight. Eastern Zone, thank you. You're welcome. Pleasure to do it. My doctor seems to think she can't fill out the function form, doesn't have weight, she needs therapy. Yeah, some of the forms ask how much you can lift. I would tell the docs, skip those questions. Or, some doctors will sit and, well, how much do you think you can lift? They ask you. This is not a formal functional capacity evaluation form that, attorneys like me send out to doctors. These are not formal functional capacity forms. These are, kind of informal, what do you think? So I would say if the doctor didn't feel comfortable filling out that question and you don't want to go through the whole long FCE exam, just skip those questions and go to the ones that you can't answer. That's all. Scaffedy 454. Vocational witness said their new full-time schedule is 32 to 35 hours on their software. So I think what you're getting at is what is a full-time job? And apparently this vocational witness says 32 hours a week can be considered full-time work. This is an issue of what you're getting into is a bigger issue of vocational witness testimony, and the standards. And here's where it kind of comes down to is that Social Security uses vocational witnesses on almost all these cases, but there's really no there's a vocational witness handbook, but there's really no standard in terms of the training they get or the background they have. It's very much, whoever's making the decision to add them to the panel for that particular hearing office gets to make that decision. Case in point, one of the things that happens at almost every hearing is the judge will ask a vocational witness, what percentage of the day can a person be off task meaning not focused on the job at hand, and still keep their job? Some vocational witnesses say 10%, some say 15%, some say 8%, some say 20%. It's not standard. So, you get in front of a vocational witness that says you can be off task 20% of the day and still maintain employment, it's going to be harder to win than one who says 8% of the day. So the same issue here is, what is a full-time schedule? I would argue that it depends on the industry. Certain jobs, 32 hours is not full-time. Other jobs, it could be. So it just really is going to depend on the particular type of job. And, there are attorneys who have very, very extensive practices in questioning a vocational witness. If I was in front of a vocational witness who said that 32 hours is full-time, I would ask where that comes from, what resource that comes from. And is it true across the board? Under what, is there any kind of law to that effect? Is that in conflict with labor laws? There's just a lot of things you could ask, and I'm willing to bet you that the answer is going to be, well, based on my experience, many employers are now, allowing people to work 32-hour weeks. And I just don't know that would hold up on appeal. I think that is, probably the exception more so than the rule for ongoing work. So, could that be something that your attorney could object to or appeal if you lose? Possibly. I just think that, the whole vocational component of Social Security is, in my opinion, kind of bogus. I mean, nobody knows how many jobs there are out there. Nobody knows how many office helper jobs there are, how many, packing jobs there are, laundry marker jobs. They estimate. And Social Security lets the vocational witnesses operate under this fiction that they really know. They're using the Dictionary of Occupational Titles, which was last updated in 1993. and they supplement it with resources that don't match up to the DOT codes. So nobody knows. We just don't know. We don't know. They extrapolate data. Well, there are 10, they call them SOC codes within this DOT code. So I'm just going to say with the DOT code, we know there's 50,000 jobs. So they're 10. We're just going to divide it by whatever and come up with a number. That's not how you do it, because theoretically you could have one of those jobs within that, the 10 is 90% of the jobs for that particular, grouping, but nobody really knows. So, one of the things that Social Security was looking at was changing the rules to reduce the reliable or dependence on age as a factor, and they backed off it. And in my opinion is that the courts are basically saying, look, if you're going to take age out, then we're going to let people start to really challenge some of these vocational testimonies about job numbers and job, availability and what the jobs mean, because you don't have reliable data. So the courts are letting Social Security live under the fiction, but they want to change the rules, then the courts may not be quite as forgiving. So I think that's what was really going on, my opinion at least. Because so far, there's not been a lot of, the courts in most circuits have not been all that receptive to the idea of just completely throwing out Social Security's use of vocational and job data. There are some attorneys who just are convinced that this is all illegal. This should be completely tossed out. The problem is they have nothing to replace it with. So, unless they change the way they define disability, that's not going to happen. But some of my colleagues, they're going to fight every single time. The statistical way the vocational witnesses operate. In fact, there was a ruling that came down where judges asked the vocational witnesses to explain their methodology to pass muster of a court case, in terms of explaining how they came up with various numbers. But even that is insufficient, in my opinion, and most people's opinion, but they let them work under this fiction. So, Scafidi, 3.5 years in, had an LJ hearing November 3rd, 20% approval rate. See, that's another thing. How can that be? How can you have, the average is 49%, let's say, you got a judge with 20%. How is that possibly fair? I was talking to a person the other day, another attorney, about a case, and his client was assigned a judge who's like notorious for being like one of the most unreasonable, low-paying judge in the entire country. And I'm like, I hate to put it this way, but you're just screwed. I mean, you're not gonna win. And it was a difficult case for various reasons. It's just not fair. But what are you going to do? What are you going to do? There's a judge in Charleston who's got a 13% approval rate. No one that I know has ever won a case in front of her. But they let her stay on the bench. But the ones that with the higher approval rates, they scrutinize. This is just the nature of the beast, my friends. This is the way it works. Okay. Oh, now that doesn't make any sense. You're saying the state DDS already affirmed you're completely disabled. Why are you going to a hearing? I guess is my question. Okay, Melissa says reconsideration denied because I meant it. And that's very likely. Usually at the state agency, if you've got a lot of education, managerial experience, there's a judgment call there about whether you have the ability to transfer skills. They're not going to typically make that call, so they let the judge make it. So you probably have a pretty good case. 2 back surgeries, 1 neck surgery, age 58. You just have to show you have no transferable skills and you meet the grids, is what I think. Look at grid 202.06 in particular. You go to gridrules.net, that's my website, and look at grid rule 202.06. That's probably your path to victory. Okay. A legal sleep doctor. Okay, not autoimmune, but various conditions. Okay. All right. Back experts lie. They're not lying. I think they're just looking at the record and giving it a very, very conservative reading is I think what's going on. Okay, I think we already answered that one. Free rep, not a lawyer, isn't getting paid. When claim passes our free lawyer. Federal court lawyer leaves my full neuro and my new autism spectrum diagnosis. So the question that Charity's asking is, she is already at federal court level and has a new diagnosis. I'm not sure that you're going to have much luck presenting that at district court level because they're really going to be looking more on what the judge's analysis was about. If it's remanded, yes, at that point you could raise the new issue. Now we'll say this, I don't do federal court work. This is probably a question that a federal court litigator could better answer. And you says you've got you're somebody who's doing this pro bono. So, I'm not sure what you're going to, how that's going to work out, but I don't know that the autism spectrum would come into play necessarily, but I could be wrong about that. How do you get, you probably can't. What you could do is fill out a form SSA 795, and you could write your observations that the doctor said this, but he never did, and object to that part of the record being considered by the judge. If the doctor won't change his record, you can just kind of put a paper easy for me to say, put a paper trail on it. Code of regulations for SSA or the CFR. Not sure what the rest of this is. Okay. They don't count. They don't care. Yeah, I'm not sure what we're getting at there. I'm sorry. What if the amount of SSD has not just cover basic needs? There's no answer to that, Daisy. It's just, there's nothing you can do. What you're paid is a function of what you paid in. And if you don't have a lot of earnings or high earnings years, your benefit amounts can be pretty small. The program is not obligated to pay your basic needs. It just pays you what the algorithm says that you're going to get paid. It doesn't pay a lot. Yeah, okay, well, that's good. That helps. Okay. I think you mean Jonathan, not Johnson, but okay. All right, let's take a look. Christina wants to see about this particular judge. Let's see if we can look here. Matt Midless, his approval, according to this site, which I use a lot, 57%, which is high, fully favorable, 51% partially, 6%. That is higher than average. So that's not a bad draw at all. I think he's seems pretty reasonable. I've never been in front of him, but based on those stats, he's pretty reasonable. And let me put the link to the place I go to look at judges' approval rates. So there you go. Here, let me put my banner back to case evaluation banner there. Okay. Trouble is I lose my spot when I go back and forth here. Okay, VE said no jobs. And judge says his CDR to 18 months. Okay, some judges will do that. They feel like you have you won the case, but the judge feels like your condition may improve. So that's what the judges do. 18 months is relatively short period of time for a CDR. Seems the judge didn't like me saying, I hope I can work. A lot of judges will say that. They say, I hope you can get back to work soon. Yeah, I don't know that a judge wants you to completely be non-functional. I just think that in every judge's mind, there's a level of evidence they need to approve, whether it's physical or mental or a combination. And some judges, that level is up here. Some judges, it's right here. It just depends on the judge. And some of them have a very, very high level of what they consider to be a disabling impairment. Are my privy to the medical records? Yes. As when I'm representing somebody, I am. Once I get access to it, doesn't always happen right away, but usually within a few weeks. But yes. Okay. I would not recommend doing this with an attorney. I tried and got it figured out. I'm very intelligent. Yeah, it's confusing. It's very confusing. And it shouldn't be, but it is. And that's, again, kind of why I do these live streams. I've got all the videos, try to make it a little more understandable, but it is confusing. It is confusing. Cherish, if I'm receiving state disability, no, would not prevent you from applying. Would not prevent you at all. Exactly what I thought. Okay, well, good. I'm glad that we are great minds think alike. How about that? I have a now former doctor without mindset of not believing in disability. He's an insurance doctor. I switched to other spine specialists at the practice. Yeah, the insurance doctors, the ones that do a lot of work for insurance companies, they are, they're looking for reasons not to find people disabled or injured. So yeah, that is not what you want in a disability case. Yeah, Charity. I mean, again, there's obviously a lot going on here, and you've got to be. You are being your own advocate. I think that's what's going on there. Trish, thank you. Welcome. You're very welcome. New here. Well, welcome. Glad to see you. Got denied. You were a millionaire movement 242, and recon for almost a year. That's too long, but it is what it is. I would probably reach out to your U.S. senator saying, I've been at recon for a year. After 7 or 8 months, it's too long. So I would definitely complain to your elected representative. 55-year-old, 2 back surgeries, sciatica, real bad in the right hip. And I worked for 2 years, but how much longer? I mean, I would tell you any minute now, but I don't know, I know certain states like Texas and Florida are really, really backed up. But I think that sounds like a pretty good case just on the face of it, what you said here. But it shouldn't be much longer, but I would probably involve your U.S. senator to get things moving, cut through the red tape. Mark Turner, brief filing got turned down in the initial, figured as much, but they said I can't work around people. I can only sit it down. Hopefully it gets better this time. Yeah, I hope so. I mean, again, your age is an important factor. Being over 50 makes it a lot easier to win. Charity, we are all very close here, but it's scary. I'm not sure what the nurse was meaning by that. They said my psychiatrist was excessive, held no weight. So it sounds like the judge did not find your psychiatrist's opinion very persuasive. Now, see, Lake City is saying V's. They are not. I mean, I'm going to tell you, I know a bunch of VEs. Now, I wouldn't say I don't go to dinner with them, but I know them just because I've been in front of so many of them. You become kind of friendly. And a couple of them, I've actually, I think I had one gentleman, if he wasn't on, maybe I interviewed him for a podcast. I might try to get him on. But, they'll tell you they're not there to hurt you or help you. They're just there to answer questions. And so if a judge gives a question and the limitations are very mild, minimal, the vocational witness can come up with jobs. Now, some vocational witnesses will come up with jobs that don't really exist because that's just on their standard list, but they're not there to hurt you or lie. They don't have an agenda. I've never met a VE I would say never, but I mean, once or twice in 35 years, met a VE with an agenda. That's just not their gig. Okay. Now, say again, if a judge says, if you were truly disassociating, you've been in a mental health facility, that's the judge practicing medicine. That's just not, judges are not capable of making that determination. That would be appealable, in my opinion. Okay, Patty Brown, they got your recon request. Hope you're approved. Have an attorney doing everything you can do. Patty, I think you're doing everything you can do. First, ALJ made mistakes. Yeah, that's why you got appealed. And that's why you're doing okay on appeal. So, okay. Patty says, I think I was denied because they didn't look at your medical history, type 2 diabetic, almost went blind, got COVID, I have my kidney. Yeah, I mean, you've got a lot of stuff going on. I had an aneurysm. If these all generate functional issues. Now, remember, Patty, you don't win with a diagnosis. You don't win because you had long COVID or because you had a partial kidney resection. You win because of the effect of these things. You got to go to the bathroom every 30 minutes. You have shortness of breath. You have to lie down and rest, for 30 minutes twice a day. You got to focus on the symptoms, not and you're 52. That helps as well. But you don't win on diagnosis. You win basically on the effect of the diagnosis on your medical issue. Charity says they look for anything not in your favor. Some do, true, some don't. It just depends on the judge. Listen to everything you had to say and I won my claim. Great, good. Reasoning, I got you. That's great. That's what you want to be doing. Very, very good. So, leave me a review, please, if you found that useful. Leave me a review. Someone to make clear. Yeah, I mean, I don't know if you have a remote date last insured or exactly what the issue is, but it can be hard. Sometimes attorneys don't want to take cases if the odds of winning are not great. So that, certainly these appeals makes it a lot more difficult. There's fewer people that do them. Do attorneys recommend I've never recommended it. I mean, I know that what you're getting at is there certain conditions have a genetic component to it. I've had clients get the testing. We submit the record to show that they are much more likely to have this condition or this reaction to a trauma or something. And that's evidence that Social Security will consider. But I've nenever suggested that somebody go out and get a DNA test. Nothing wrong with it, but I just don't know that that's as good of an evidence. Because again, DNA is probabilities. You have DNA. Let's say you have the BRCA variant, God forbid, which is likely to get breast cancer and I think ovarian cancer in females. So you have the BRCA, and maybe it's 70% chance that but 30% of the time you won't. So the genetics just say that you're more likely than not, or much higher or slightly higher percentage to get these conditions. Look, I did a genetic test, not genetic test, but I did it through 23andMe. And so I looked at the results and it says, I likely have a higher percentage of fast twitch muscle fiber. Well, if you watch me in the basketball court or the tennis court, I guarantee you, I ain't got any fast twitch muscle fibers. If I had some, they long gone. So, that's what this said. It also said, what did it say? There was something in there that something that said that it was just completely not me, that I can't remember that, what it was, but, so I mean, something was ridiculous saying you're likely not to like M&Ms. Like, no, that's absolutely, I love M&Ms. So that's not me. It was just something that it was completely incorrect. So, DNA, and that's obviously a 23andMe, DNA test. It's not a medical DNA type of test for a disease, but it's going to probably talk more about probability. So I don't know as persuasive as an MRI, let's say. The judge I have in 2 weeks is 55%. Lisa Groenveld Mygier. Let's just see if I see anything about her. Oh, there she goes. Now I'm showing 75%, 66% fully favorable, 10% partially. So she has, according to this resource, a much higher than average approval. So I think you got a great judge, is what it looks like to me. Christina says, please leave a review. Yes, please. It would be much appreciated. Here's where you do it.
Just go to jonathanginsberg.com. You can also do it there. But yeah, please, that would be great. That would be great. And yeah, and if you're not represented and you are interested in having me look at it, ssdanswers.com, and I've got a form you can fill out. I think it's I have it on the crawl most of the time here. I just put the one with the review, but other one I've got the crawl. What is the amount you get from SSDI? But depending on how sick you are, no. Gets worse, doesn't matter. You get what you get based on your work history. Yeah. Can I apply for SSDI? Yes, you can. You would get the difference between early and full if you want, but yeah, they're not exclusive. Once you're on full retirement, you wouldn't, because you can't get any disability, because that's the same as full. But if you're in early, you can get the difference between the two. Lake City, making the case right, having your congressperson do a congressional inquiry. I agree. I would absolutely agree with that. It's very helpful. Makes things move along. Absolutely agree. Starting 2017 by myself, and in May of this year, so it's time to get a lawyer. Yeah. Okay. I agree. No, that's okay. That's okay, Christina. Sometimes it's just spell check will do it, but no problem at all. Look, people, I grew up, with the name Ginsberg. People pronounced it spelled it all kind of different ways. A lot of times B-U-R-G or G-I-N-Z or, Gainsborough or Ginsberg. I mean, you name it. And Jonathan spelled different ways. People spell sometimes J-O-H-N-A-T-H-A-N or J-O-N-A-T-H-O-N. At the end of the day, it doesn't matter. I mean, it's just, but obviously, if you read How to Win Friends and Influence People, Dale Carnegie's book from the 30s, whatever, a person's name is the sweetest sound he will ever hear or she will ever hear. So, just as a matter of, I don't really care for me, but just saying in general, it's worth making sure you spell the person's name right or pronounce it right. People appreciate that. Again, it doesn't bother me at all, because I know, that's not what you're here for, is to get information. That's what I'm here to give you. And my name is not sometimes the easiest to spell or pronounce. But just in general, look, when I do a brief, I will tell you, I look at the hearing notice and I always double check that I spelled the judge's name right. Because, if the judge is Judge Williamson and I call it Judge Williams, that's, that looks sloppy. And, judges, like a lot of attorneys, we tend to be very detail oriented, and judges will pick up on stuff like that. I mean, spelling mistakes in briefs, I always double check it, because they, just don't give a judge a reason to think you're not prepared. I remember, I kind of always go into these war stories, but I'll tell you this one, because I thought it was kind of funny. Years ago, I did a lot of bankruptcy work, which I don't really do anymore, but I did for years. And there was a judge in the bankruptcy court near Atlanta who was known for being really persnickety. I mean, she was just a real hard ass. I mean, just not the nicest person in the world. Very bright, and I think probably a pretty good judge, but just didn't make life easy for anybody. And I used to go sometimes early. If I had a hearing, I would watch the other hearings going on, just because you always learn by watching. And there were like 5 or 6 attorneys presenting it was a Chapter 11 business bankruptcy to this judge, and they had submitted I guess it was a brief or something. And so you got these 5 or 6 lawyers, and in Chapter 11 bankruptcy work, these are corporate bankruptcies. At the time, they're probably charging $700-800 an hour. So you got 5 of them sitting there, and the judge looks at them and says, the rules of the court say that the margins for these type of submissions, the brief or the whatever you submitted, it's supposed to be 1.5 inches, and yours are only 1 inch. I need you to go back to your office today, right now, and reprint this and bring it back to me before the end of business. So, you got 5 lawyers probably billing $700-800 an hour each, having to basically go back to their office, reprint this, spend another 5 or 6 hours by the time
all is said and done, probably cost their client another $5,000 or $6,000 because this judge was pissed off that, excuse my French, was upset that the margins were, an inch instead of an inch and a half or an inch and a quarter, wherever it was. Some judges are like that. Now, not in Social Security, I don't generally find that. Although, again, there was a judge. I did a brief I submitted a couple of days ago. When I looked at the hearing notice, and I've learned over the years to do this, if you're going to submit a brief, do it 7 business days beforehand. Others, I'm not going to look at it. Okay, because a lot of times I'll submit briefs more quickly or within 3 or 4 days because new stuff comes in and I want to be as up to date as possible. But now I've got it marked where I'm going to make sure I get them submitted. I've never had a problem, never had a judge not read it or consider it. But, now that they're starting to put that language in there, I'm going to make sure I follow their rules. So, that's just the way it is. But yeah, some judges can be very particular. All this getting back to Christina's point is, I don't care if you misspell my name, that's fine. But I think in general, if you're dealing with judges, with Social Security, take the extra time and make sure you spell it right, because it's good. It can make a difference to people. If their ego's bruised, you don't want them to go in with the first thing they see is that you misspelled their name. You don't want to do that. So just an observation, life lesson, as it were. My poor son would cringe when he hears the word life lesson, because one of his parents, not me, is fond of those. So anyway, good input on my hearing. User one claim fully favorable. Do I get back pay? Assuming that you were found disabled, several months or years ago, you would be. You'll get a letter to explaining what you get. So, if the judge used an onset date of October of 2025, no back pay. But if the judge used onset date of let's say before March or February of this year, you'll get some. Hopefully, a lot more. Okay. Thank you. You're welcome, Charity. Thanks for stopping by. Lake City Bricks, using a dresser and other obsolete jobs. Stupid have an agenda. Last we said microphone processor. Well, again, the vocational witnesses are using what's available to them, and the DOT does include things like microfilm addresser because it was last updated in 1993. Social Security came out with several emergency rules, and among those was they identified a certain number of jobs. I don't know if I can find that for you real quick. Social Security rule obsolete. They came up with 114 of them. And let's see. I think it's this one. Let's see. I don't want to waste a lot of time with this, but yeah, okay. Here is this one here. Okay, let me just show you this so you can sort of see what I'm talking about. Share screen and here it is. Okay, so this is Social Security will do these things called emergency messages. This one's EM 24026, and it's basically occupations we will not use to support a not disabled finding. So they're not going to use this to deny cases. So here are examples of them. Like radio station operator, a telegraph operator. How many telegraph operators do you need? Wire transfer clerk. Nobody wires money anymore. It's done typically in a bank. Telegrapher. Character impersonator. I guess there's not very many of those. Domestic cook. Most people don't have cooks come to their house. Scuba diver. That's interesting. Embalmer. I guess there's not very many of those. But they list camera repairer. Most people, they just buy another camera. Watch assembler. So there's a bunch of the dredge operator. And basically what it says is they're not going to look at these jobs, there are 114 of them, And they're going to say that the only way that the vocational witness can use them if they have their own evidence that in fact there are, you know, oops, that's not there. Let me go back to this other one here. But basically that if there are these jobs that they know exist, I mean, surveillance system monitor for years was a job that Social Security used to deny cases. Social Security is basically saying, we're not going to consider that anymore because the job is not really, doesn't exist the way it did back in the day. So, you know, it's just, they're in the process of trying to update all this stuff, but it's not always going all that well. And they still rely on jobs that don't exist. But the vocational witnesses, as long as it's available to them. Now, look, most vocational witnesses, if you're in, you know, Kansas, you know, they're not going to identify a job for a dock worker, you know, an ocean dock worker or something like that, because there are no jobs in Kansas for dock workers. There's no oceans in Kansas. But again, the way the law is written, are there jobs that exist? And, you know, I don't know that it has to necessarily be in your area, but most vocational witnesses will limit their answers to jobs that really do exist in the local area. But again, I come back to, they're not there to hurt you, in my opinion. Took me 6 months to get access to your electronic file. That seems a little long, because I'm getting them in 2 or 3 weeks. Let's just say that if I really was, okay, I'm not sure where there. Information, appreciate the hard work you did to help us out. Sure, my pleasure, my pleasure. My first ALJ called drinking Coca-Cola a poor diet choice. Yeah, you know, I mean, I remember there was one judge in Macon who, if you smoked, he was going to deny your case. He just wouldn't tolerate it. You know, I don't know that judges really have the right to comment about your choices. I mean, obviously, if obesity is an issue, you're diabetic, you shouldn't be drinking Coca-Cola. And one could argue that a diabetic who's drinking 3 or 4 Coca-Colas a day is really not being compliant with doctors' orders. I think that's probably legitimate. But yeah, there are judges who are going to make observations that if you're not helping yourself, they're going to hold it against you. You know, whether that would be appealable or not, you know, I don't know. I mean, you know, if a diabetic has a Coca-Cola once a month, I don't think that is a poor diet choice. Maybe it's not a greatest idea, but I don't think that goes to the level of poor diet choice. If you're having 3 or 4 Cokes a day and you're diabetic, yeah, that's a poor choice. And I think judges can consider behavior that is, you know, not consistent with your doctor's recommendations, that you're being non-compliant. You know, and non-compliance is kind of a tough call because medications, you know, if you're supposed to be taking medications, but they have side effects, are you being non-compliant? But if they don't really have side effects, or if they control your condition, I mean, a lot of times in mental health cases, people will not like the way they feel on, you know, Prozac or Xanax or something like that, but it controls the symptoms. Are you being non-compliant if you don't take it? Some judges will say yes, and I think that could be upheld. So I think it just, you know, I don't know, the Coca-Cola, I think it depends on how many you're drinking. I'm awesome. Well, I appreciate that very much. Florida. Yes, please reach out to your senator. I think it's Rick Scott and forget the other one, but yeah, reach out to one. Don't just to both. Reach out just to one. On the UK suspending jury trials for crimes with sentences under 3 years. That's an interesting question. I mean, I'd heard about something like that. A little bit beyond the scope of our live stream here. Realize that they're not suspending trials, they're just saying no jury trials. Jury trials are very expensive for, you know, jurisdictions to hold. And I don't think England has a constitution. So it's not unconstitutional, but I think if there's a rational basis for it, and I'm not sure how the court system works there, they can look. We went to 6-person juries in the United States. there's some places where you don't have to have an anonymous, a unanimous, let me say it correctly, jury vote to convict somebody. So the law is being tweaked. So, this is basically saying that a judge can make this decision. That's the law. And if that's what the law says and it survived challenges to the extent that they can challenge it in England, then, that is what it is. Judges have biases, and, juries sometimes can be better, sometimes not as good. It just depends. I don't know enough about it to really have a strong opinion, so let me pass on that. But just to say that as long as it meets the constitutional muster, then, it is what it is. And what we think about it doesn't matter, is what I'm getting at. Lisa Register, I haven't worked in 2 years. Lisa is anxiety is a problem. Do not recon level, something to the psychologist said I should win. Appeal, absolutely appeal. Yes, I would absolutely appeal that. And if you've got good support from your treating doctors, then, absolutely, I would appeal. I was fully favorable. Do I get my back pay? Assuming that there's back pay to get, yes. I finally went case treated now, got my home attendant to help me. Then they gave me SS. Good. That is good to hear. 17 months after first filing my case, has to go to hearing if I'll make it. No, it won't. It's a dire direct request. You still have to go through recon. But I would definitely contact your U.S. senator on that. You can do a dire need, but I would start with the senator. That's going to be more effective, in my opinion. What if I have a gene mutation? Yeah, that is evidence you can use, no question about it. And the blood work confirms that you have this mutation. That would explain the symptoms. That is very, very good evidence. It's objective evidence. So I think that's helpful. You're welcome. Press like, everybody. Yes, please press like. If you will, that would be great. Thanks for the video. It's my pleasure. Any change? No. No change to the grid rules at this point. We're good to go. Okay. We talked last week. Appeals attorney Leeds ended up going pro se, found way too many serious symptoms to be a point of rational inquiry and OIG. Good. Okay. Very, very good. Fully favorable to go. Okay, I think you've already answered that. I've been in therapy over 18 years. Okay, and again, that's very helpful evidence, long-term evidence. Absolutely. Free advice, hit the like button. Yeah, go for it. Absolutely. I appreciate it very much. Okay. Oh, boy. That's fine. Christina, don't worry about it. It really doesn't bother me at all. Doesn't bother me in the slightest. Let's see here. We're getting another 5 or 6 minutes here. Short form CDR. Do you know how long it will take for approval? How long is the approval CDR? Okay, the short form CDR means you've already been approved. How long will it take for them to make a decision? That could be 2 to 6 months. Let's see. Vocational rehab worker, driveway job. I think that's evidence. If they can't find a job for you, that's evidence that you are not very employable. So that goes to the heart of the issue in the Social Security case. Absolutely. If I denied by the appeals council, it can go to the federal court, but avail the LGMS have done something wrong. My first step, not diabetic. This guy was just a jerk. Yeah, and there are some that are like that. Absolutely. Who have knowledge about using Premier Disability Services. If they're non-attorney reps, I don't ever like to speak ill of anybody. That doesn't mean I'm not making any comment about Premier Disability Services. I personally think attorneys bring something to the party. I know some non-attorney reps who are very, very good. So I think you have to just do your due diligence, ask a lot of questions, ask how the communication will be, how the process works. Will they try cases, or do they have contract attorneys who try cases who you've never met before? I would just ask questions. Are they going to kick people off? I think there's, over the past few years, whenever they give Social Security money, they want it applied to CDRs. So that will remain a priority, I believe. It's not. Non-unanimous verdict is not appealable if the law allows for it. So, again, this is just a function of resources, and the Supreme Court, or whatever, probably the Supreme Court has made, I think it was the Supreme Court, as a matter of fact, has made a decision that the interest of the state in saving money, and the interest of the state in, saving time, because going through a whole voir dire of, a huge jury pool and trying to get 12, that outweighs the harm potentially done for a non-unanimous jury. So obviously, if the Supreme Court says it's okay, then it's okay. I mean, legally, you may disagree with it, but the Supreme Court obviously said it was okay. Have two claims, one reconsideration or hiring a law firm. Okay, so you got two things. Yeah, you might want to have your attorney try to get that straightened out. Legal aid not passively denied 10 days. Okay, thank you. You're welcome. Please ask any veteran with 100% PD to submit veteran-related VA letter decision. Yes, you want to make sure, even though it's not binding on Social Security, if you're 100% VA disabled, that'll get you to the front of the line. So you definitely want to do that. Plus, it's a factor. Corlil, how are you doing? Lily, let's see, send me the following claim from SSA. Mine was code MRP that says 7 years. Okay. So the code MRP seems to be the factor here. Okay, please don't forget to like and share the live stream. Okay, that would be great. And I'll just saying, and we're kind of getting to the end here. We're almost at 2 hours. Obviously, if you like this, please do give me a like on the video, and if you are inclined, fill out a review. I've got on my let me put the banner up here. You can go here, this bit.ly, or just go to jonathanginsberg.com and just click review me, and you can do a review and just say that I was helpful if you found I was helpful. That really helps me. Those reviews mean a lot because the search engines like them, and it helps my websites to rise. So that would be much, much appreciated. And I would also tell people I've got an Instagram channel, Ginsberg Law Offices. I've got a TikTok channel. I'm not sure what the name of that one is, but just look up Jonathan Ginsberg there. Anybody who's on those platforms, Instagram, TikTok, please, subscribe to it. I'm trying to build that up. I've obviously got a big YouTube presence, and I don't want to rely just on YouTube. So anybody here who is willing to help me to, subscribe to these other channels, again, like the Instagram or like TikTok, I'll try to get the links for next week. Please do. My Facebook page, Ginsberg Law, please like that, subscribe to that. It just helps me build things up. And I know a lot of people here are regulars, and I would really appreciate that very much. Let's see, we got a couple more comments here. Flown under the radar my whole life. Brain is not working. Okay. It sounds like, Charity, you've been struggling, and I'm sorry that you've had to struggle, because it's very tough. It's very tough out there, as you all know. Yep. Okay, and we'll leave it at this. Christina says, leave a 5-star review and comment, please. That would be great. Christina is like my president of the Jonathan Ginsberg fan club in California, which I really appreciate. So she's here every week, and anybody who's here every week, thank you for taking your time. I know time is valuable for everybody, and I appreciate that. And I like sharing what I know, and I hope that you find this useful. Like I think I've told you, I believe in good karma. You send good stuff out in the world, try to help people, and it comes back in your favor. So that's what I try to do. So okay. Okay, we'll look last comment about the VA. Let's see here. The VA decision letter and DRBQs makes it difficult for the ALJ. And don't know that the judges of Social Security are going to be too bound by anything the VA says. I mean, they'll look at it, but it's helpful, but it's not going to be binding on them. So anyway, all right. Have a great weekend, everybody. I hope that you all stay warm. I'll see you back here next week, and I'm gone. So let me know if I can be of assistance, ssdanswers.com. Otherwise, I'll see you next week. Bye-bye.